Yes, Mr. Herbert.
Can I just, I should just come back very shortly on the provision which I slightly inadvertently took everyone to before the short adjournment. As it happens, as is always the case, it's helpful to my case. That was section 388.3. One thing it does is it provides the answer to a question that was asked yesterday, which no one seems to know the answer to, which is there any situation where you have a decision notice which is not preceded by a warning notice? That was in the preceding provision, paragraph 3882. So it's page 100, I've jumped right into it, my lord. I apologise for those who put it away. It's page 149 of the first.
Thank you.
Section 388.3. It provides the answer. This is an example of a decision notice without a warning notice, actually, which was the question raised on the previous subsection.
What is?
If section 2 was if a decision notice was preceded by a warning notice, the action must be under the same part.
Yes.
And I think it may be Milady who asked, is there any situation in which a decision notice is not preceded by a warning notice? And my friend thought he on his side, they didn't know of one. In fact, the very next subsection provides what is probably the only example, which is where the subsection I was referring to before the short adjournment, where the regulator, before it takes the action to which the decision notice, the original notice relates, gives the person concerned a further decision notice which relates to a different action in respect of the same matter.
So there have been one warning notice, but not a second warning notice.
There's been one decision notice.
And one warning notice before the first decision notice.
Precisely.
So it's not quite a case without a warning notice at all, but...
That's true. Yes, but there is effectively a promulgated new decision notice with an action which hasn't got an associated warning notice. But yes. I just thought that's incidentally, it may be an answer. The point of the section is that it's the one section that actually liberates the authority from having to be in respect of the same matter in the same part of FSMA. It actually here is saying you've given one decision notice. This may be contemplating settlement. This may be a provision to facilitate settlement. I'm sure Mr. Thornton and those behind Milan Friend are more likely to know the ins and outs of this than anyone else. But it may be that to facilitate settlement, the regulator's given a decision notice either of its own volition, initiation. It has second thoughts, or to facilitate negotiation after the decision notice. It's then empowered to give another decision notice, another decision notice relating to a different action, even maybe under a different part of FSMA, in respect of the same matter. Okay. And the only, what I seek to take from that is it has to be in respect of the same matter. And we say matter there is not just, can be anything. It's actually saying your allegations, your case is the same, your allegations are the same, your case is the same, but you can change, maybe after a settlement discussions, you can change the action. And you can actually change the part of FSMA. You're completely empowered to do anything in FSMA in relation to the
Yes.
You're not suggesting though, as you suggested before the short adjournment, this might relate to something that happens after you've been to the tribunal. You're not suggesting it's
I think I'm wrong. I think I was wrong on that. There's a separate mechanism for that.
And I understand your argument as to what same matter means here, but we don't really get that out of this section.
No.
Do we? I mean, it's just it's a large here, or up for debate here, just as it is before the tribunal.
Yes, but my point is that what this section I would respectfully suggest does contemplate that same matter is exerting real control in not advancing a new case. What this section is doing is giving the FCA the ability to change the action by way of a new decision notice. Mm-hmm. But it's not saying if matter meant unconstrained, as Millennium Friend says, you could write a completely new decision notice with new allegations without even going back to a warning notice stage. It would be bizarre. So we do actually say that this section indicates that matter had much more control than that, was not allowing the authority. Well, this section is not trying to give the authority the power to write a completely new case against the person, new allegations, new facts, new matters, whatever, without going back through the whole statutory process. It's a specific targeted process, letting it change the action.
Well, maybe it says that matter means something, but it doesn't tell us what it means.
No, it doesn't. We say it supports our case, that it ties it closely to the existing allegations.
But you say, I think, the fact that this will occur without a second warning notice suggests that they oughtn't to be entitled to do it unless there's quite a close connection
Precisely.
between
Precisely. Precisely.
what is done and what was in the first decision notice.
You accepted, I think, that the decision notice doesn't need to be a word for word what's in the warning notice, so you can take what the warning notice is,
Yes.
and you can change it slightly, maybe in the light of
Or large,
representations.
or massively.
This indicates that as my lord just said, you're not going to get a new warning notice. So again, it's based on what's in the original warning notice, but it can still be changed.
New action. You can have a new action. Different action in any part of FSMA. It's only dealing with changes of action, we say.
Thank you.
So, my lord, my lady, where I reach on, just to tie up my submissions on action in the same part of FSMA, if my submissions are right, if they find favour with the court, we say that does two things. First of all, it dispels the basic construction argument plank from a learned friend's primary case. He bases his case firmly on action in the same part of FSMA as being the only control, and for the reasons I've submitted, that just simply there has no force of reasoning at all. But secondly, it also rebuts the principal criticism which my learned friend makes of our case, because he says, well, if you can change the action, as long as it's in the same part of FSMA, then surely you must be able to change the allegations as well. Indeed, it might make the allegations provision OTOs. And we say not so, because as I've illustrated, the two concepts are completely separate and one can change one without the other. Just drawing the consequences, we say, are both for his case and for our case. Lord and Lady, in view of the time, I'm not going to address separately the secondary and tertiary case of my learned friend. In short, we say that neither case is really derived in any logical way from analysis of the words in the statute, and they both suffer from, well, the second case suffers from a real difficulty as a jurisdictional case of not only uncertainty as to its derivation, but imprecision of its terms, arises from the same factual situation, otherwise connected with the circumstances, the evidence, and the allegations that were before the decision maker. That's paragraph 9, the formulation in paragraph 95 of his skeleton. They are very, very uncertain as to what's arising from the same factual situation, what is otherwise connected, what is the connection, and even more oddly, connected with the circumstances, the evidence and the allegations. Well, evidence, we all know, can change. There's no fresh evidence in the tribunal is fine. How could you have something that limits your jurisdiction by reference to the evidence when that evidence can change? Does that mean that the allegations can also change? We say it's not, with greatest respect, it is not a formulation which can derive from the way the words are used in the statute, and the same applies in relation to the tertiary case. I then turn to the relevant authorities, and I'm going to need to as it were, pick my mark here, because there are quite a lot, and in my last hour I can't address them all, but I can perhaps mention them as I go through and take the court to the most important. And I do aim to show how a consistent line has developed, and that the Jarbray line, I can call it that, Jarbray in the following cases are not different from the case that the tribunal came to in this case at first instance, and are wildly different from the cases which my learned friend is seeking to advance to this court. The first substantial analysis is Parker. I'm not going to go back to that because you've already had it referred to. There are only two paragraphs which are really relevant, and they've already been addressed. That was a disciplinary case. Paragraph 21, the chair held that the matter referred to was the contents of the decision notice, so it's supporting our primary case. I should have given the reference. It's A3, third authorities bundle, tab 32, page 547. And at page 554, paragraph 21, held that the matter referred to the contents of the decision notice, so it wasn't permissible to include a new allegation, additional allegation of market abuse. in paragraph 23, she distinguished new evidence, but that is as far as the case goes. The case that I obviously do need to take you back to is the second in time, which is the Jarbray decision, which is tab 35 in the Third Authority bundle, starting at page 679. And what happened at the RDC stage in this case is, we say, important. As one can see from paragraph 11 of the decision, which is page 681, the warning notice sought withdrawal of approval on grounds of breach of Principle 1 and Principle 3, on the basis that not fit and proper because of a deliberate scheme of market abuse. In paragraph 12, one can see that following the end of the RDC process, the decision notice imposed only a substantial fine for breach of Principles 2 or 3. So there was no Principle 1 case or finding of unfitness. But at the end of that paragraph, one can see the decision notice did refer to making no findings on the more serious case. So the decision notice did refer to the case which it didn't embody allegations of in relation to. In paragraph 14, the FCA statement of case then, disagreeing with its own RDC, sought to reinstitute the more serious fitness case. This wasn't an amendment case like here, it wasn't seeking to amend its statement of case, it was embodied in the original statement of case at the tribunal stage. Mr. Jarbray contended that it had no jurisdiction to advance such a case. So the first point, my lord and my lady, is that contrary to what my learned friend said, this was only a backwards-looking disciplinary case in the form in which it was presented to the tribunal. In terms of it was referred to the tribunal, because Mr. Jarbray was referring to the tribunal a decision to fine him for breach of Principles 2 and 3. There was no fitness case that he was referring to the tribunal. My learned friend referred to it as a prohibition and penalty case. Obviously, there was a prohibition floating around, and that was what was sought to be introduced. But in terms of what the jurisdiction was, it was potentially subject to the amendment being allowed, which it was. It was a disciplinary case. Now, if one then turns to the crucial part of the operative part of the judgment, that starts at paragraph 28. And if I could pick it up in the interest of time, line 36, 37. Instead, it is the allegations made in the decision notice and the circumstances on which these are based that fall to be considered and evaluated. This is an important holding. They comprise the matter referred. So it's the allegations made in the decision notice and the circumstances on which they're based. It is in relation to those circumstances and any further relevant evidence, that's the fresh evidence provision, that was not available to the RDC, that the tribunal's function is to determine the appropriate action for the authority to take. The indications so far are that the circumstances, the evidence and the allegations before the RDC and not the decision are the subject matter of the reference. The second point is that in the present case, the facts and circumstances on which the authority relies in its statement of case were before the RDC. They are either set out within the decision notice or are recorded in the decision notice as matters on which the RDC did not reach a concluded factual finding. In this respect, it can be said that the facts and matters before the RDC are the facts and matters relied upon by the authority for the purpose of the present reference. This is not, and then he distinguishes Parker. This is not a case such as that considered in Parker, where a new allegation unconnected with the factual context that gave rise to the original decision was sought to be raised, nor is the present situation comparable to that found in Ryder, which was a pensions case. There, the matter that Mr. Ryder had sought to raise related to factual issues that had not been in front of the determinations panel of the pensions regulator and therefore formed no part of the body of facts to which the determined notice related. This was an earlier case than ITV, and there's a line of earlier pension cases, but at that time, that was one referred to. So what can be seen is that the tribunal clearly widened Parker, we say slightly, by loosening matter from allegations made in the decision notice to include associated circumstances, by which it meant matters that were before the RDC, because they were in the warning notice and were debated before the RDC, and potentially, whether this is necessary or not is a question, they were recorded in the decision notice as being matters on which the RDC did not reach a concluded factual finding. And Parker is therefore different because the allegation there had not been ventilated at the RDC. And that interpretation is the interpretation of Jarbray, which the tribunal here gave. See paragraphs 55 and 57 of this tribunal's decision.
One way of reading 29 is that it just records that these matters were in fact in the decision notice in this case, rather than saying that gives you the limit.
But they weren't in the decision notice. The decision notice mentioned that they had been in the warning notice.
Yes.
But these were new allegations in the sense, outside those in the decision notice, in that they made new factual allegations as to state of mind. I mean, it was dishonesty, wasn't it?
Yes,
I mean, that's a new. I mean, in your taxonomy, that's a new allegation.
Yes,
that's not evidence.
Absolutely.
That's a new allegation of conduct of a particular kind.
Yes. The breach of a different.
Not only breach of a different principle,
but also allegation.
but also a fresh allegation that's not in the decision notice.
But we do say, well, but potentially it's unclear how much of the actual evidence changed, or whether it was just a different conclusion or the same facts. But it looks like it. What was sought to be reintroduced was referred to in the decision notice, but it potentially wasn't all there. But in answer to Milady's question, we submit that these paragraphs are doing more than that. There isn't a separate holding, because we're going to come on in a moment to action and the conclusion that the tribunal, that the Act expressly contemplates the tribunal determining as appropriate action of a different nature.
Well, the critical point may be the first sentence of 29. The facts and circumstances were before the RDC.
Lady, when we say that is the Jarbray loosening, absolutely, I agree with your ladyship. But what I would suggest is that the judge, Sir Stephen Oliver is he's looking at Parker and he's saying this case is a bit different. Parker had said it's just the allegations in the decision notice, so that's the starting point. He's working with that, indeed expressly distinguishing it and saying no, it goes a bit further than that. It may also be the facts and circumstances in the RDC. So I agree with Milady. It is not clear that the necessary part of the loosening was the fact it was recorded in the decision notice as having been rejected. The relevant part of the loosening may be it was in the warning notice, and you, Mr. Jarbray, were fully able to debate it at the RDC. So I accept that, and indeed subsequent cases grapple with that. What if it's not in the decision notice?
Yes, but it says facts and circumstances. It doesn't say allegations.
No, and I say that the circumstances are referring to those that are not in the decision notice, but are encompassing what went on in the RDC, including and indeed in the warning notice. So,
but on its particular facts, circumstances meant allegations,
and
not just evidence of
indeed
indeed existing allegations. Yeah.
That the loosening was the consequence of the loosening is that new allegations were allowed in.
Yeah.
If they'd been in front of the RDC, I accept that, and that is effectively our alternative case, which is we say the Jarbray holding. Our alternative case is that Jarbray is right, and that what you can allow back, it's based on the allegations in the decision notice, but Jarbray says you can go beyond that if it's been presented to the RDC, it's been in the warning notice, and therefore there's been an opportunity to debate the matters at the RDC. It may be, and I accept ladyship's proposition, that it's not necessary to the decision that it was also expressly rejected in the decision notice. Why does that make such a difference on my task if it's not an allegation in the decision notice? That is enough. That is the loosening, which then allows the matter to be prosecuted in the tribunal. Now,
You
our
said
primary
that's-
case,
You said that's your alternative case. Your primary
Yes.
case is that Mr. Oliver got it wrong.
yes, our primary case is that it should have, Parker's right, it should just be allegations in the decision notice. And the reason we say that is because strictly, matters which the RDC doesn't uphold or that it rejects in the decision notice can't, on a linguistic analysis, be part of the matter referred because they're not allegations in the decision notice against the subject. And their referral would involve the vice of the authority, at least to that extent, second-guessing its own independent decision maker, and potentially would exercise a chilling effect over the referral, as indeed occurred in the case of Jarbre, who promptly discontinued once it was found that they could run a fitness and properness case against him. On the other hand, I accept that the decision, as the Jarbre decision with the loosening, doesn't compromise the right to reasons in the warning notice. The person has had a full and proper opportunity at the RDC stage to debate those allegations and knows what they're all about. And so at least some of the ill effects of permitting the authority to go beyond the decision notice are not present. So we can see the force to some extent in the Jarbre, the Jarbre loosening, and we gratefully adopt it as our alternative case if our primary case is seen as being too strict. And as I said at the outset, it really makes no difference for the fact of this case at all. So I'm really addressing this on the basis that it's line drawing and assisting the court with where the line ought to be drawn in our submission. But what we don't say is appropriate. My learned friend then sought to elevate paragraphs 30 to 31, which are dealing with the same action reasoning, to a stretch that we say they can't bear. The conclusion of those two paragraphs is at the end. It is, it must, we think, follow that the Act expressly contemplates the tribunal determining as appropriate action for the authority to take action of a different nature to that covered in the decision notice. Well, that's plainly right, and that's what the action reasoning is doing, and I've made my submissions on that. I'm not going to go back to the case of Whitestone, which is, for the court's note, tab A7, bundle A7, tab 61, page 1768, which is another decision of Tribunal Judge Harrington, a very recent one this year and long, because on the principal point, it was in a sense quite a straightforward case. There, it was a fitness case. There were allegations which had not been set out in the warning notices, particularly relating to a third FX transaction. They were not set out in the warning notices, but they were raised in canvas during the RDC process, and they were embodied in the decision notice. And the tribunal, rightly at paragraph 385, we say, concluded that in relation that the tribunal has jurisdiction to consider the allegations based on facts and matters which were considered before the RDC, whether or not those facts and matters were relied on in the relevant warning notice. That must be plainly right. There's no same action requirement, same matter. The matter doesn't reach back to the warning notice. Clearly, from the paragraph in the section, is referring to the decision notice. So we say that was I won't say, and I know it wasn't a straightforward case in many other ways, as my learned friend who was involved, no doubt, will be able to tell one. But on this aspect, it was actually an easy case in that sense. There was then a long discussion of discretion in the case.
The paragraph, sorry, was 3.
985 is the crucial paragraph, milady, of we say of the decision. There is quite a long review of the Jarbre. It's in the appendix to the decision. There's quite a long review of the Jarbre case line. But in fact, it's we say a straightforward decision on the proper tests. There's then a case, a Nazia B, and the which is back in September 2011, and that's in tab 39, page 987.
So you're not taking these chronologically. 2011.
Yeah, I apologise. I took Whitestone out of chronology because but I'll try and go back to a chronology now. I am otherwise trying to be chronological.
Thank you.
September 2011. This we say is an orthodox.
Sorry, where is this?
Tab 39, page 987.
Thank you.
I'm not going to take you to it because it was an orthodox application of Jarbre. the decision notice is an alleged breach of Principle 6, due skill care. There was an attempt by the authority to introduce in the tribunal a case of breach of Principle 4, being openly cooperative with one's regulator, after the authority had discovered that the subjects had attempted to mislead it as to their financial means at the internal RDC stage. So this was a new allegation based on new evidence. The tribunal, paragraph 13, spotted the Jarbray issue. We had doubts at that stage. This is after the hearing. They asked for written representations on whether the Principle 4 charge was within jurisdiction. The authority then confirmed that there could be no separate penalty for breach of Principle 4. And the tribunals effectively set out its view, paragraph 36. There was no jurisdiction to entertain the Principle 4 breach. The authority wanted to sanction this misleading. It had to do it by way of a separate warning and decision notice. It was a separate matter. That's quite a strong case because it was clearly very bad conduct, misleading, trying to reduce the penalty by misleading the authority as to means. Discovered at the effectively at the tribunal stage, not allowed to bring that case in because it had no, the tribunal had no jurisdiction to entertain the breach. And we say it's absolutely right. There's no reason to skip out all the internal decision-making stage in relation to something which was a separate allegation. I've already addressed Allen in 2013. There's then also in 2013 the case of Hobbs, which did go to the Court of Appeal, and my learned friend took you to as a Court of Appeal decision, although on the Jarbray matter it has not much to say because it proceeded by way of agreement. But maybe because my learned friend took you to it, I could shortly go back to it. It is tab 45 of the authorities bundle, page 1125. This was the case where Mr. Hobbs was originally found in the decision notice to have engaged in market abuse and that he wasn't fit and proper. On reference to the tribunal, it found that Mr. Hobbs had not committed market abuse and allowed the reference. The authority appealed to the Court of Appeal, not on the basis of the market abuse finding, but on the basis that the tribunal had wrongly not considered the authority's case that he was not fit and proper as a result of lying during the investigation, which they found as a fact. And perhaps not surprisingly, the appeal was allowed. The construction of the matter, as I think my friend showed you at paragraph 32, proceeded by agreement. Happily, Mr. Jaffe and Mr. Hunter agreed that the facts and evidence referred to in the decision notice, on the basis of which the authority concluded that the person in question was not fit and proper, was not a fit and proper person, and that the prohibition order was appropriate. The word included, the reference to evidence there is rather too odd. It's arguably too wide because one doesn't normally fasten on evidence. But what is clear is that the decision proceeds, we say rightly, by reference to the contents of the decision notice. It's totally inconsistent with at least the primary and secondary case that the authority now advance. The authority, learned friends, sought to place some reliance on the observations of Sir Stanley Burnton at paragraph 38. But we say that these are absolutely common ground, and we don't support any criticism of our case. What is said is that it is plainly I'm sorry, but I'm just trying to find the passage. Yes, of course. The very first sentence, paragraph 38. In my judgment, it is important for the tribunal to consider all the facts and evidence put before it on a reference under section 57. Now, under section 57 is a fitness reference. So learned friend relied on this as potentially suggesting a much wider jurisdiction. Evidence, of course, is not contentious, but all the facts put forward on a reference. But here we have a section 57 fitness reference again. So this, we say, is explicable. It's a forward-looking case. It is a case where the tribunal had to consider whether Mr. Hobbs' the time on ambulatory basis was not fit and proper, and it has wider evidential nets that we submit exists in such cases. And there was clearly no or extremely limited argument on the job rail authorities or any further analysis of how that fits. So that really is as far as that case takes us, and we say it doesn't.
But nevertheless part of a consistent line of authorities for Barras purposes.
It's totally consistent with Java and the other case, but it doesn't take it much further forward. I wouldn't press that as a matter on which you could rely for Barras purposes, because the matter is effectively agreed. It's not debated. It can't be. That can't be. I don't think that could really be constituted as an authoritative determination. It's certainly consistent, but I think I would be a little ambitious to be putting that in the forefront of my cases I rely on.
Right.
There were then cases. Marku, I mentioned. I'm not going to go in the time available. I'm conscious I have other matters to deal with after jurisdiction. There is Marku at tab 60, page 1674, which is a forward-looking prohibition case. But perhaps more importantly, because it decides on the same point, and it's a more recent decision, is Burdett and Goodchild, which is at tab 96, page 2570. It's a decision of the 3rd of April 2024, so it's not going to be much good for me on any Barras principle submission.
But just before we get there, if we're looking at things chronologically, you haven't dealt with Wilford in its place.
I'll deal with Wilford as one of two response cases, ITV and Wilford. I'll deal with next.
Right.
Wilford doesn't effectively. My submission, Wilford takes us absolutely nowhere because there's no analysis, there's no discussion. It proceeds by agreement, and it's not even a case in the trial. It's a judicial review decision.
It is, but it contains a statement by Lord Justice Morbid, which says that on a reference to the tribunal, the FSA may, if it thinks fit, broaden the scope of its allegations, provided they relate to the same matter. Now, I quite understand you'll say that's an aside, and it may not be closely reasoned, but it's difficult to fit that in with your Barras principle, consistent line of authorities, isn't it?
In that case, in the first place, the Court of Appeal did not consider at all the circumstances in which additional allegations not canvassed at an earlier stage could be entertained to the Upper Tribunal. Neither Section 133 nor any of the authorities considering the matter were referred to in any judgment. And indeed, that proposition which your Lordship has put to me was very unusually, in that case, advanced by the authorised person. This was a judicial review, and it was an authorised person at paragraph 18, you can see, who made the submission, who was seeking to make a submission of prejudice that he would face from the lack of the reasons in the decision notice. So almost uniquely in this line of cases, was wanting to say, look, the authority could do lots of horrible things to me in the tribunal, and I don't have proper reasons for the decision. So that's paragraph 18. And the authority, perhaps understandably, didn't challenge the proposition as to the wide scope of the power. There was no live issue on the point, and the court simply proceeded at paragraph 37 on the agreed assumption that there was a risk that the authority might put forward additional allegations. So we respectfully say that one can't really extract anything from that case of use. Can I come back shortly to Burdett and Goodchild, tab 96, page 2570. This is a strong case because here the authority applied to add an allegation of breach of principle 2, use, skill, care and diligence, against each applicant as the alternative to an extant case that they had of lack of integrity. You can see that from paragraph 27 of the decision in terms of page 8. I apologise, I have two. It's on page 2578. So So they wanted effectively to make a lesser allegation. They wanted to make an allegation of due skill, care and diligence. This is an amendment case as an alternative case to lack of integrity. There's a detailed analysis of the Jarberry case law starting at paragraph 38, which is how journey starts, including an analysis of this case in the tribunal, paragraph 50 to 57, and the pensions cases. The judge resolved at paragraph 78 to follow the BlueCrest line and another case, BlueCrest line, in not permitting the alternative argument, unless it was, as it was put in the test, in his paragraph 78, unless it was of the same nature and based on the same facts as allegations which were. He concluded that a change from principle 1 to principle 2 involved making an allegation which was of a different nature in principle, even though it was a lesser allegation, and further pointed out some of the material differences between the two. In particular, paragraph 81, one sees, they see the paragraph 80 is talking about the attractions, counsel for the authority saying the attractions of allowing an alternative and lesser charge. And I do note at line the authority put the case that the authority doesn't, and then no offence said this, the authority doesn't generally plead negligence as an alternative to recklessness, principle 1, where they are both value judgments which could be reached in relation to the same conduct. The tribunal said, I pause to observe that this is a surprising position to adopt, bearing in mind the observations in Marku and an earlier case. The tribunal was indicating, well, why on earth don't you plead alternatives? And it may be in the light of this decision that they now will. But what we say the tribunal rightly found at paragraph 81 was, although it was attractive to say why shouldn't you allow a lesser case, they don't consider it's an approach they should adopt. At 171, the tribunal in BlueCrest very clearly stated there should be a hard edge between hitherto unarticulated allegations which form part of the matter referred and those that do not. The hard edge is the same nature requirement, and whatever else may be an allegation, whatever else may be an allegation of a different nature, allegations referring to different regulatory provisions will be. To adopt Mr. Temple's approach would be to blunt the hard edge. In any event, I'm not persuaded that an allegation of failure to use due skill care is of the same nature of an allegation of acting recklessly and without integrity. For example, the decision noticed the authorities say Mr. Burnett was aware of the obvious risk, that the portfolios were high risk, etc., etc. His conduct was reckless. And they make the point, halfway down that paragraph, to my mind, there's a material difference between alleging that someone has been reckless, as alleged here, deliberately carrying on in the face of a known risk that made the proposed course of action obviously unsuitable, and alleging that a person did not have or did not use the required level of skill care or was not sufficiently careful or diligent. While an allegation, next bullet point, while an allegation of negligence is clearly less serious than one of recklessness or dishonesty, it is not a trivial matter, and so on and so forth. So we do commend this decision to the tribunal in the sense that it is preventing a lesser charge to be added on the basis that even in such a case, it's not an allegation of the same nature. It's a different allegation, and it's not to be permitted. And then the last authority that I need to address you on, I hope, is the ITV decision, on which my own friend placed considerable weight. ITV was the latest in a series of decisions involving the pensions regulator, permissible scope of new cases in that context. And we do say there's been a general recognition, both in the pensions cases, as you see in this case, and in the financial services cases, that neither is of great assistance in elucidating the jurisdiction of the other. Because although there are marked similarities between the reference procedure under the Pensions Act and under FSMA, there are critical differences which mean that the test for regulatory action is different. And can I simply make a number of points about the differences? First point is simply that...
Where is ITV?
ITV is tab 48, page 1233.
Okay.
The first point is that it's worth noting that in the ITV case, no one was even arguing that the tribunal didn't have jurisdiction to entertain a new case. Clear from the head note, the second paragraph, on appeal by the companies, contending that the regulator had to show good reason for departing from its case in the warning notice or in the determinations panel. And that's confirmed in paragraphs 35 and 36. Lord Target's submissions, Lord Panic QC, who led on this issue for the Targets, submits the proposition that the regulator may not raise allegations which were not part of the warning notice or within the findings were not part of the warning notice or within the findings of the determination panel, unless the upper tribunal is satisfied that there is good reason to do so. He made a number of submissions in support of that allegation, and indeed the previous paragraph, parties' arguments on whether I should have read 35 first. Parties are deeply divided. Targets contend the regulator has to show good reason for departing from its case in the warning notice or the determination panel. The regulator contends there are no restrictions. Say those. The trustee contends the upper tribunal has to perform a balancing exercise and be satisfied it's not unjust. So there were 3 cases being put to it, deeply divided, but none of them were saying you haven't got any jurisdiction at all.
Isn't the first one a jurisdiction point?
First one is saying you must have good reason for departing from its case in the warning notice or the determination of the determinations panel.
And that's not derived from anything in the case management powers. It's derived from some threshold requirement. That's the argument, wasn't it? I mean, how could that not be a jurisdiction point?
Especially given the next sentence.
The next sentence is the regulator contends there are no restrictions. Those.
Yes. And this is either a jurisdiction point or a case management point, isn't it?
Well, I read this, and I'll look further. But I read this as Lord Panic for the Target saying you need good reason if you want a new case. That's not a jurisdiction point, but is establishing a sufficient justification for being allowed to amend. The regulator is saying no, I don't need good reason. I can do what I want. I can add in a new case whenever I want to. And the trustee being somewhere in the middle, you've got a balancing exercise to do. But in relation to my Lord Justice Popplewell's point, can I park that for a moment, Lord, and continue with my other reasons? And if I'm wrong and it is a jurisdiction point, then I'm sure I'll be corrected. But it's only one of a number of objections to taking the pension line of cases as helpful authority in this context. The second point is that there's a very important difference in the pensions context, and this is a point that Milady put to my own friend in the course of his submissions, in that in the pensions context, it is the determination of the pensions regulator that is the matter referred to the Upper Tribunal. This is section 96(3) of the Pensions Act, which the court has at bundle authorities first bundle tab 6, page 200. And the meaning of determination.
Sorry, just give me that again. Where do we find 96(3)?
1 tab 6, page 200. If that's right.
Yes. Yes, that is right, I think. Right.
I apologise, my lord. I'm pausing, Lord, because my next point is that it's the meaning of determination, which one can discern from 96(2)(c), is the determination whether to take the regulatory action under consideration. On T's and C, the consideration of any such representation and the determination whether to take the regulatory action under consideration.
So actually, it's the action that's being
Indeed, it's more like the action. It's a sharp contrast to the issue of the meaning of the matter. how that relates to the contents of the decision notice. In the pensions context, the determination itself, which determination, i.e. the decision, rather like the action, which may be supported, it may be decided in the pensions context by new allegations. Thirdly, unlike section 387 of FSMA, the Pensions Act does not prescribe the contents of statutory notices. That was noticed by Lady Justice Arden at paragraph 58. Indeed, the pensions regulator itself publishes a procedure. And as the Upper Tribunal noted in the Whitestone case at paragraph 1000, tab 61, page 1971, as far as the intention of Parliament is concerned, the position as regards the importance of the warning notice is stronger in the case of FSMA than it is in relation to the Pensions Act, given the requirement that the warning notice must contain reasons for the proposed action is mandatory. But perhaps also more fundamentally, the nature of a dispute in Pensions Act cases is different. Instead of a two-way regulatory dispute between the authority and the
subject. Sorry to slow you down. I'm just trying to get my head around your point about what is referred. What is referred in the pensions context is the determination itself, which is the action. Therefore, you say it's not surprising that in the pensions context there should be a wider jurisdiction to consider any reasons for taking the same action.
Good, yes.
Whereas, where in the present context the provision is where a decision is taken, the matter may be referred. That involves narrowing the jurisdiction, even though one might think that the word matter indicated an intention to confer a wider jurisdiction.
Precisely, my Lord puts the point
So
out.
matter actually is referring the matter as opposed to referring the decision involves a narrowing of the jurisdiction of the tribunal.
I took that too
That's
fast.
right.
Yes, that's my submission.
Although one would expect matter to be something wider than just the decision itself. So
Well,
that does seem to me paradoxical.
Yeah. Well, my submission is it's the allegations in the decision. You have my submission. There is one more fundamental point about the Pensions Act cases, which is that it is, instead of a two-way regulatory dispute between the subject and the authority as envisaged in FSMA, subject only to a very limited third-party rights regime to protect a third party's reputation in particular passages, the pensions regime, the reference procedure is much wider. Anyone that persuades the Upper Tribunal that it's directly affected by a determination can make a reference, section 96(3)b, 99(7)b. Parties other than the target may well have an interest in the proceedings and an entitlement to put forward their case, most obviously the trustee of the relevant scheme. So, for example, if the target happens to be an employer or someone associated, you've also got the trustee, as occurred in ITV, where the trustee was advancing independently its own case, and they can put in a reference advancing its own case. So the jurisdiction of the regulator to advance a different case from the Upper Tribunal has to be considered in the pensions contest against this background of a potentially multi-party dispute where other parties will anyway be putting in separate cases. It's obviously more difficult to conceive of a regime which, not impossible, but more difficult to conceive of a regime which jurisdictionally limits the tribunal to a case advanced in a warning notice or a determination where third parties haven't subscribed to that instrument and may be advancing a different case anyway. So we say that there are good reasons why the two streams have not really mixed, as it were, and in Granada itself, the Court of Appeal didn't find that it was assisted by any of the FSMA cases that were cited to it, see paragraph 72, to which have already been referred. Can I turn then, and I'll have to take this rather shortly, to the application of the tribunal's jurisdiction to the proposed amendments. The second contested amendments, and then the third and fourth contested amendments. And in fact, in substance, I'll be able to take them together because we say the consequences in relation to the third and fourth contested amendment follow if you're with me on the second contested amendment. Obviously, on one I'm challenging the decision of the tribunal, the second contested amendment. On the third, fourth, that there is effectively no decision by the tribunal. And you will recall that the additional pleading referred to as the second contested amendment set out in the judgment at paragraphs 97 to 99. I won't go back to it. You'll recall that it concerns what we say is a new case, the new case of BlueCrest breaching duties owed to investors pursuant to its MSA activities, the Master Service Agreement activities. So I do emphasise at the outset that our case is not seeking to take advantage of a technical case that, as my friend put it, they got the right provisions but just put them in the wrong order, or some slip of that sort. Our case on the second contested amendment, and indeed the third and fourth amendment, is more fundamental. It is that they were seeking to run a substantively new case by the amendments in each case, and that's what I'll need to demonstrate to the court is what the existing case was and how the new case arose. The tribunal, although it made some forthright criticisms of the way the decision notice was drafted, didn't accept my case and held that you could discern from the decision notice, at least in nascent form, in sufficient form, the broader case, which we say is not present. And I seek to persuade this court that the tribunal was wrong to conclude. It's misinterpreted the case that was being put. There's no dispute between the parties, Lord Milady, that the decision notice contained a case of breach of Principle 8 by BlueCrest arising from three basic factual elements. This is really the decision notice, paragraph 4.4. The carrying out by BlueCrest of the regulated activity of managing investments, I'll call that the managing activity, and associated with that making arrangements with a view to transactions and investments. Secondly, the carrying out of that activity pursuant to the agreement, the sub-investment management agreement, the sub-IMAs. And thirdly, the third limb is the failure to adequately manage a conflict arising between its duties to the external fund and its the internal fund, pursuant to the sub-IMAs with each. There was a dispute, to which I'll return in a moment, as to whether the original decision notice identified the client to whom these services were provided, and thus to whom the Principle 8 duties were owed. But it is, as the judge rightly found, the correct client was the external fund, because it was the only counterparty to the sub-IMAs on that case. And the judge was right so to find. But we say the judge was wrong to say that there was an additional case, a nascent in the decision notice, which went further than that. Can I first analyse the position by reference to the decision notice, which is in the supplemental bundle at tab 12, page 426. And I should perhaps, just before I jump into that, should perhaps, for clarity's sake, say where I'm going and identify the new case, which we say was put by the second contested amendment, which is not to be found in the decision notice that I'll be showing you. So you have that in mind. We say that the second contested amendment case arose firstly from a different regulated activity, arranging or bringing about deals in investments. I'll call that bringing about activity. And if that was pursuant to a different agreement, the master sales agreement, which I'll call the MSA, and in respect of a different conflict of interest, which we don't consider has yet been adequately identified. So we say that the case that was brought was a case of the familiar case of a breach of conflict of interest under the sub-IMAs, preferring one client internal fund to another client external fund, or risk of that, and not properly disclosing to remediate that conflict. And the quite separate cases which are sought to be introduced by the amendment is a case to do with promotion of the fund. It's pursuant to the master sales agreement. It's effectively not clear, fair, and misleading promotion of the fund by reference to the conflict of interest allegations. Now, if one goes to the decision notice, the activities on which the case is set out in the decision notice are based emerged from the failings section, page 459, headed failings at the bottom of that page. And one can see it addresses solely the activities of BlueCrest in managing the fund. So one sees the first sentence of paragraph 5.3, BlueCrest's role in the management of the internal fund and the external fund resulted in a conflict of interest. And then if we see paragraph 5.9, as outlined in the preceding paragraphs, at all material times, BlueCrest and then various bodies that were part of BlueCrest had responsibilities in respect of managing the internal and external funds, including the allocation of capital and so on, monitoring and conflict of interest, and then various particulars under that, in which that management is said to have been infected by a conflict of interest and which was not properly managed. And what one sees consistent with that, the only regulated activities that were identified in relation to the management role of BlueCrest are back at paragraph 4.4, the decision notice, page 433. This is the beginning of the background. During the relevant period, BlueCrest managed both the external and internal funds. I won't read all of this. Paragraph 4.3, in discharging its responsibilities, the investment manager appointed sub-investment managers, that's BlueCrest. During the relevant period, BlueCrest was authorised by the authority to carry on various regulated activities, including managing investments and making arrangements with a view to transactions. Its range of investment management and other functions included portfolio management, legal compliance, risk operations, and investor relations. Now, there is also a section of the decision notice that concerns the adequacy of the disclosures made by way of presentations and prospectuses to the underlying investors. But that is raised solely to substantiate the allegation that BlueCrest failed to disclose the conflict of interest as part of its management role. So the court will recall that under the approach to conflict, CISC 10.1.8, page 399 makes this clear, the authorities. If arrangements...
Sorry, 10.1.8, did you say?
10.1. This is I'm referring to CISC. I'm just the relevant rule in relation to conflicts requires that if you can't resolve a conflict internally, get rid of the conflict, then at the very least you must disclose the conflict to your clients. That's 10.1.8. In that case, you must clearly disclose the general nature and or sources of conflict or conflict of interest to the client, and that requirement is actually recited in the summary of reasons section at paragraph 2.2. And it's also, I don't need to take you to it, back in the failing section 5.6 and 5.9c. No steps were taken to manage the conflict by providing sufficient disclosure to investors. So the relevance of the disclosure to investors is you had this conflict and you didn't manage it by doing proper disclosure. But there's no reference to the regulated activities now relied upon in the second contested amendment, the bringing about activities. And that's consistent with the lack of any investigation of those activities at all. As the tribunal correctly found, paragraph 177, it doesn't appear that the investigation ever addressed BCM UK's regulated activity of making arrangements with a view to transactions through its marketing and sales role, paragraph 177. And consequently, this activity and associated regulated activity did not form any part of the regulatory proceedings by way of the warning notice and then the decision notice, wasn't foreshadowed, and didn't and couldn't form any part of the decision notice, which was of course in substantially the same form as the warning notice. And it's irrelevant that Mr. George, as he did in his submission, pointed out to a passage in an earlier draft annotated warning notice, which did correctly identify BlueCrest's additional status as a sales agent pursuant to the MSA, the other agreement. You'll recall paragraph 4.23, the 4 paragraphs which were correctly set out and then later mangled, as he put it. And in that earlier version of the notice, there was a correct reference. It was only a reference to the different hats BlueCrest wore as effectively sales agent. But our point is not that it was just that it disappeared. The point is that even at that earlier stage, that BlueCrest status was just referred to as by way of enumerating what its roles were. There was no case built on that. There was no case at the earlier draft annotated warning notice stage that performing activities pursuant to the MSA, BlueCrest had committed any failings or anything like that. There was a mention of it, but no more. And consistently with that, if one considers the relevant contractual agreements relied on in the decision notice, it's clear that the agreements themselves relied on in the second contested amendment does not embody the MSA, not that relied on in the decision notice. So the decision notice solely concerned the activities of BlueCrest under the sub-IMAs. There was a specific section in the decision notice, starting at paragraph 4.20, on the responsibilities of BC MUK as sub-investment manager. That paragraph and following, setting out BlueCrest's duties in respect of the sub-IMAs. There's simply no section, equivalent section on the MSAs. As the Upper Tribunal correctly found at paragraph 97 of the decision, the MSA is mentioned in the MSA only once in passing, as the Tribunal put it, and that's paragraph 4.61 of the decision notice. And that significantly comes at the beginning of a section telling the story of BlueCrest's disclosure regarding the internal fund to external fund investors. So this part of the notice is dealing with, you had a conflict of interest, and now let's look at what you said about it. Did you disclose it? And if you cut a very long story short, this section goes all the way through to paragraph, for a long part of the notice. What this is doing is criticising the disclosures that were made. In essence, they're saying, not only did you not properly disclose the conflict, it was effectively obscured or certainly not disclosed. And at the beginning of that section, all this paragraph we submit, 461, is doing, is explaining what it was that BlueCrest was doing in providing all these investor presentations and due diligence questionnaires and everything that follows. It explains that pursuant to the Master Services Agreement, Master Sales Agreement, MSA, BlueCrest was appointed by the investment manager to market and sell subscriptions to investments in the external fund. This included BCM UK providing presentations and issuing marketing materials to prospective investors in the external fund. These responsibilities were primarily carried out by the sales and marketing team. So that's the reason it's mentioned, explaining why it is that BlueCrest is pumping out all this material. And it is addressed in the decision notice, because obviously that could have been one route by which BlueCrest discharged its conflict allegations under the sub-IMAs if it had probably told everyone about the unresolved conflict of interest. And this part of the notice is saying it didn't do that, but by any manner of means. the long section from 4.62 to 4.102. That's why the judge rightly found that that was only a reference in passing to the MSA. And my case on this is further submitted if one considers the third element that I identified at the outset, the nature of the conflict of interest relied on. Once again, the conflict in the decision notice doesn't correlate to any activities under the MSA. Principle 8 provides that the firm must manage a conflict of interest fairly, both between itself and its customers, or between customer and another client. And tribunals already established through questions yesterday that there's no distinction here between a customer and a client. It's the second part of the principle that we're involved with here, between a customer and, you could almost say, between clients, or the customer could be the external fund and then the client could be internal. That's the conflict in any event, that the two funds were in conflict with one another in relation to BlueCrest's activities. But the customer-client conflict only arose between the external and internal funds as a result of BlueCrest being sub-investment manager of both funds. That's why that conflict arose. And the conflict relied on in the second contested amendment has to be and can only be something different, because what the authority is now complaining about in the second contested amendment is that in providing all these disclosures under the MSA, BlueCrest was not acted in a way that was not clear, fair, and not misleading, the breach of the Cobb's rule, sorry, not breach of the breach of Principle 8, on the basis of disclosures to the investors. And that clearly, it may be a case based on conflict. So I made a misstatement there. It's not a case based on clear, fair, and not misleading. It's a further Principle 8 case. So it is still a case. I apologise to the court. It is still a case based on Principle 8, a conflict case on the face of it. But it can't be the same conflict, because the conflict in pumping out information to investors is not a conflict between the internal fund and the external fund. It is some different conflict. So we say, to putting all that together, the Upper Tribunal was wrong to conclude that the Second Amendment case had been made on the decision notice. The error which we say that the Upper Tribunal fell into in reaching that finding was one. The decision notice has a number of passages in which the authority appeared to be proceeding on the basis that the Principle 8 duties were owed to the external fund investors rather than the external fund itself. And there were various stray references to investors around, which the judge rightly found was erroneous. The judge identified that error in various parts of the decision. For example, paragraph 2.11 of the decision notice shouldn't be, not usually owed to the investors, it's only owed to the fund. But because there were these erroneous references to duties being owed to external fund investors, the tribunal inferred that they must be, i.e. must have been intended by the authority to be, a reference to duties owed to them under the ISA. And they put that together. MSA, I apologise. It put that together with the fact that there were copious references to the inadequate disclosure, and put that together and made a case of breach of Principle 8 by disclosure to the investors. Hey presto, there's a case under the MSA. And that conclusion is expressed in paragraph 35 of the decision, i.e. that there was an articulated, if unclear, MSA case in the decision notice. In fact, as we submit, the references to duties being owed to investors were merely a consequence of the authority's misunderstanding of the party to whom the management services under the sub-IMAs were provided, really the external funds, and were not any part of a case under the MSA. That was a case advanced for the first time in relation to the second contested amendment. And that same reasoning, effectively, my lord and lady, is the basis of our objection to the third and fourth contested amendment that the tribunal didn't allow. Before I mention that, and in my last few minutes, I should say, note back that if I were to persuade the court that I'm right in my analysis of the decision notice and the second contested amendment, it also stands for my duty case that I postponed from the first part of the case as to why the authority's case does not embody a duty requirement. Because if I'm right and the second amendment is not allowed, the authority is then left with a case that relies on a breach of a regulatory requirement, Principle 8, that is only owed to clients under the IMA, i.e. the external fund and the internal fund. And they have no tenable case in respect of the investors. And therefore the redress being required in the supervisory notice is redress in respect of persons whom there is no tenable case of a breach of duty. So the two, in a sense, go together. The duty case as to why, if I'm right that the second amendment shouldn't be allowed, there's a gap as to duty, rests on the same reasoning that I've advanced as to why the second amendment shouldn't be allowed. And then the third and fourth contested amendments, effectively, in at least one part, rely on the same basis, because there's two objections to the third and fourth contested amendments. One is the headline one, which is that you shouldn't allow new allegations of breach of Principle 7 and COBS, full stop. But secondly, we do also say strongly it's not simply a relabelling case. We also say that the breach, the new principal breach and the COBS breach are attached to the new case, the MSA case, not to the old conflict of interest case.
You've lost me as to what point you're on now.
I apologise.
So far as amendments 3 and 4 are
Yes.
concerned, there are a number of questions. One is whether, if you're right on the scope of the jurisdiction, they fall outside the jurisdiction.
Good, yes.
I think
And that's what I'm addressing.
that
Yes.
necessarily follows, because your case on jurisdiction is you're not allowed to rely on a new breach.
So that's my first point.
So that's the first point. We need that. And then the second point is,
yes.
if you're wrong about that and there is jurisdiction,
If relabelling doesn't fall within the jurisdiction test, if they would be entitled to make the new allegations,
yes,
there is a further case why it still should not be within jurisdiction. I'm contemplating if the court came up with a test for jurisdiction which allowed through the third and fourth amendment, if all that was wrong with them was that there was a new principle and a new COBS rule labelled on the breach, then we say there's a further reason. There's two separate reasons why it is jurisdictionally objectionable, if I can put it that way.
right. So we're still on jurisdiction.
Yes.
So the second one relates to the tertiary case, doesn't it? Really? You're saying it's not just relabelling.
Yes, precisely, my lady. So the first is the first is you shouldn't allow in the new charges anyway. But the second is this is more than relabelling, because the new charges are attached to the new case that I've just identified. They're not attached to the old conflict of interest case. COBS and P7 say nothing about conflicts of interest. They are saying, this is, I misspoke earlier and started talking about clear, fair and not misleading. This is where they come in. They are saying all your disclosures to investors were not clear, fair and not misleading. So they attach to the new case that I've sought to demonstrate to the court. And that is a further reason why, even if the court were to adopt a looser test on jurisdiction, there would be a substantial objection to the case on that basis too. And one can see, if one looks at, I'm not going to go back to, if one looks at 42B of the statement of case, which if it encapsulates the third and fourth contested amendment, makes it clear that it's about communication to investors of misleading information as part of its MSA activities. So it's clearly an MSA case that was never put originally in the decision notice. And that is a further substantial reason why the third and fourth contested amendments should not be permitted as a matter of jurisdiction. Lord Lady, I'm looking at the time. The only topic left on which I'm not going to address the tribunal substantively is discretion.
Yeah.
Can I just say 2 or 3 points about discretion, which might be of assistance? That the discretion is in our skeleton, and we rely on the matters there. And in practice, many of the matters which are set out under jurisdiction may also obviously be pressed on the court if the court were to determine that there is jurisdiction and moves on to consider a discretion aspect. In the first place,
in that eventuality, you too ask us to make the decision, do you?
I would be content with this court deciding if the court was minded to correct and remit the principle, the second contested amendment discretion for any reason, then perhaps this one ought to be remitted with it, because the two very much go together. But if effectively one's looking at this one, we would be content for the court to deal with it.
Thank you. Yes, I interrupted you. Go on.
As to the principles in play, my lord, we say that there are 2 principles you effectively consider together, because this is both an application to amend, and as is set out in the skeleton, you're looking at Rule 5.3c in relation to an application to amend. There's the case of Bitter, and there's authorities in relation to that. But this is also, of course, or should be, an application to make a new case that was not made in the decision notice, effectively. And if one looks at Whitestone in relation to discretion, you were showing that a little by my learned friend yesterday, paragraph 999 and following, that tribunal considers that the authority should be obliged to make an application to permit a new case to be advanced, assuming there's any jurisdiction to do so, and justify it. And they indicate, and this was a matter that was looked at a little yesterday in interchanges between my learned friend and the court, about the power of the tribunal to effectively control the admission of a new case. And we would respectfully agree. It looks like it arises from the general case management power under Rule 5.2, read, of course, with the overriding Rule 2. And when one's considering the principles by which the control of that new case should be managed, there is in Whitestone, tribunal may want to look at. I'm not going to go back to it now, given the time. Paragraphs 74, 76, Whitestone. Sorry. This is a reference to the BlueCrest, the decision of the tribunal applying Whitestone, paragraph 74 to 76, page 252 of the bundle. If the amendment that the authority was seeking to admit is one which could have been included in the warning notice but was not, then the burden on the authority to satisfy the tribunal that the new allegation should be pleaded will be a heavy one. So we do commend that, and at paragraphs 1000 to 1012 in Whitestone, reference 61, page 1971, there is a long passage where the tribunal articulates a number of reasons why such a heavy burden ought to apply in the light of the importance placed on compliance with the statutory warning procedures and for other reasons that the court might be assisted by in considering the exercise of that discretion were you to reach that stage. Other than that, I'm content to rely on the points made in our skeleton in relation to discretion.
Can you just tell me what is unfair about it? About allowing the amendment if there is jurisdiction to do so? What is it that makes it unfair to you to allow it?
Well, in the first place, many of the same. It depends on what you've decided on jurisdiction. Many of the same points which inform. Which I have pressed on the tribunal as a reason why jurisdiction should be very limited if you disagree with me and make jurisdiction wider, apply with equal force to applying a very heavy rule at the discretion stage.
Right, but
So
there's
all
a
the general
balance to be had, and you've emphasised what the factors that should weigh heavily.
Yes.
That the FCA should
there's-
put into the balance.
So there's two
But
things.
what goes into your side of the balance as to why it's unfair?
Specific matters to this case. Well, first of
Yeah.
all, we would say that there's no good reason for why any of the amendments couldn't have been brought at an earlier stage.
But
And the-
I'm asking you, what makes it unfair? I mean, you're going back to this is what the FCA should be having to do.
Yes. Well, there are fundamental unfairness, we say, in allowing a regulatory case to reach the stage of the tribunal, not having complied with one's statutory duties to provide reasons, for example, in the warning notice, so that BlueCrest could consider what its response to it was, and then to advance them for the first time in the tribunal. So there's an unfairness in having been deprived of statutory protections at the warning notice
But
stage.
you've got an opportunity to consider and forward your response here.
Well, we're in the tribunal process. It's a completely different process. I mean, one is entitled to go on defending oneself in the tribunal, but with great respect, one should not.
I mean, I can
this-
understand if you put in evidence, say, well, if only we'd known this was in the arena, then we might well not have
Yes.
made a reference. But I suspect it would have been difficult for
We
for
certainly
you to have put
we
forward that
certainly haven't
evidence.
put that matter, but with the greatest respect, I suggest that your lordship is looking at this through the perspective of civil litigation and whether an amendment would be allowed. And we say there's a completely different frame of reference which the court should be considering and which Whitestone advocates, which is there's a heavy burden on the authority. Never mind whether the applicant can demonstrate prejudice. The subject, there's a heavy burden on the authority.
And I understand all that. I'm simply asking you:
Is there any additional
is there
capacity?
any prejudice?
Well, the only prejudice that could be identified is that there is a decision from the RDC on a more limited basis, and now there is a new case of the tribunal on a more searching basis with new allegations that we have to face, and that's not something we should be facing.
Is that a coy way of saying you'd be deprived of a Henderson and Henderson point?
No, that's not. That wasn't the way I was putting it. It was more that there is a important regulatory process that should have been gone through that would have protected, would have given BlueCrest rights, which it hasn't received if the matter comes to it for the first time at the tribunal stage.
So I'm going to write down. You're not saying that there's prejudice in being deprived of a Henderson and Henderson point. Thank you.
Lord, my lady, unless I can assist the court further, is my submission.
Thank you very much.
My lords, my lady, may I follow the same structure as we have both used in our submission? So I go right back to the start of my learned friend's address and the issues of redress and initially issues of statutory construction. You have our starting point that there is nothing in the plain wording of section 55N which would lead you to the conclusion that the principal construction for which we contend is either absurd or unreasonable. I've only 2 points to note in that particular area. Firstly, I originally took you, my lord, to paragraph 19.3 and 19.4 of our skeleton and did not have the authorities in the bundle there. May I confirm they are now part of the appellant supplementary bundle? And perhaps just invite you to look at tab 7, page 101, which is the quotation from Rudovitz.
Yes.
And my Lord Neuenberger, Master of the Rolls. So paragraph 30 is a licensing case. Mr. Fordham's case, however, goes further in that it involves saying that this long-standing approach adopted by the Secretary of State sets the bar too low, and in that I consider he is wrong. Section 25(2) appears to confer an unfettered discretion on the Secretary of State, and is, at least in the absence of special circumstances, inappropriate for the court to treat a statutorily conferred discretion with no express limitations or fetters as being somehow implicitly limited or fettered. Accordingly, unless there is some justification for doing so, it is for the Secretary of State to decide on what grounds and in what circumstances to grant a licence, and apart from an obligation to act rationally and otherwise in accordance with the general law, including that relating to human rights, there should be no operative fetter or presumption. And that, in a sense, encapsulates my case upon the true effect and construction of Section 55L, with the added point that it is clearly not an unfettered discretion as identified here, because it has trigger criteria and judicial review plus and all the other matters we discussed. The only other matter to hand up, again with apologies, it wasn't in the bundle. My Lord Nugee, in the discussion of one of those protections, the fact there is a consumer protection objective that is clearly defined in quite detailed terms within the Act, quite rightly identified, well, consumer must be defined in order for that to work, or is that a freestanding word? So I'll just hand up section 1G, if I may, which contains the definition, just to highlight that, again, it is a very carefully crafted definition. This is the opposite of freestanding words given unconsidered powers, and to highlight in particular that consumers are both past, current, and indeed future, and if I may just draw attention to 1A, persons who may use regulated financial services or services that are provided by persons other than authorised persons, and then in C, who have invested or may invest in financial instruments. So it is both defined and circumscribed, in no way unfettered, but at the same time encapsulating future consumers as well as past consumers. Now, my lords, my lady, the one area I wanted to take a little time of, rather than just making reply points, was that I was accused by my learned friend of having failed to take sufficient account of what he called the enormous importance of the chronology, and importantly, what the position was in 2000, as it were, on our respective cases. So I'll just say a little about our case in relation to FSMA as originally acted, which of course is that this power existed all the time, including upon enactment. As I understand my learned friend's case, in Authorities Bundle, tab 2, page 13, he starts with section 45.4 and says that the permission extends to including any provision that could be included if a fresh permission will be given in response to application under section 40. And then, going back to the imposition requirement in 43.
I'm so sorry, I'm in the wrong volume. Volume.
I'm now at page 10 of the Authorities Bundles when you're back.
My fault. Yes.
And states that that means that no backward-looking requirement could be imposed. We say that's wrong, and I draw attention, my lord. 43.1 is in perfectly general terms, a Part 4 permission may include such requirements as the authority considers appropriate. And a requirement then in 2 may in particular be imposed so as to require the person to take specific action or to require him from taking specific action. So on its face, there is no reason why a backward-looking requirement to pay redress could not be introduced, but I understand my learned friend's argument to be that because this is something that could be included in only in a fresh permission, you have to effectively rewrite history and pretend that everything that has actually happened hasn't happened. In other words, that this is a fresh application by somebody applying for the first time, rather than simply treating it as a new application by the same firm, perhaps after a lapse in time. In our submission, there's no basis for that submission. The true construction is to simply posit the fact that if BlueCrest had applied for authorization in, say, 2002, a requirement to impose redress for backward-looking activities could have been imposed had that been the first time that they applied for authorization. You don't write out of history what in fact has occurred, whether that's in the context of authorized or unauthorized cases. So in our submission, it is clearly the case that this power existed from the time that FSMA was enacted. And I think my learned friend accepted that that was indeed true in respect of a requirement to pay money in respect of, and the example given was a pre-existing county court order, because, as my learned friend emphatically put it, that has nothing to do with financial services. And my lord raised the point, well, it might or might not, depending upon whether the claim had been claimed for breach of statutory duty under FSMA itself. But either way, what my learned friend still seemed to want to hold on to is the proposition that in 2000, this power could not be imposed in order to achieve an effect which could be achieved using one of the other tools in the FCA toolkit without satisfying the conditions required to use that tool. And we say there's no basis textually for that submission. But even if in 2000 we went that far with my learned friend and accepted that you had to satisfy the requirements of other tools in the toolkit, at that stage, the FCA has no power to ensue a consumer redress stream. The sensible analogy would be with section 384 at that time, even if my learned friend were right. And of course, that doesn't require loss, as we know from page 28 of the bundle, subsection 1b. And it doesn't require the quantification methodology of the English courts, as we know from subsection 5 in page 29. The amount that can be ordered is that which appears just, having regard to the profits accrued or loss suffered, not by reference to the way that the English court would construe it. And nor is there any duty condition in section 394. One can see that there may be a causation requirement under one limb of subsection 1, i.e. subsection 1b. But once you have established that somebody has suffered loss as a result of the contravention, there is no further requirement that there be a correspondence, the duty requirement, between the target of the requirement and he or she who has suffered loss. So even if my learned friend was right, and we can't see how he is, that in 2000 you have to look at the other tools available for redress and impose those sort of limitations on a section 45 power as it then was, the furthest that can get him are the limitations within 384, which obviously don't contain actionability, don't contain loss in the way he forms it, and don't contain duty. He may get causation, but that's the highest he could put it. And of course, if one looks at the Ombudsman, there is a complete width. None of his 4 conditions arrive there because of the fair, just, and reasonable basis. And so we can see no basis, obviously, on our primary case, but even on my learned friend's case, as to why in 2000 the power to impose a redress scheme didn't exist, at least insofar as it also satisfied the requirements of 384. And if that's right, then it has some significance for my learned friend's case when we get to 2010. So let us now go to page 193, if we may, in section 404F7. Now the court has our principal points, which were helpfully referred to or characterised as the double distortion point of language, and there's nothing I have to add to that. My learned friend's case involves reading the word if in a completely different way, and it then involves reading those doubly permissive requirements may be included in the permission or authorization as varied in a completely different way. But let us assume for the moment he's right about that. What is the effect of his construction? It's not just creating a power to introduce a scheme that corresponds to or is similar to a consumer redress scheme. It is also removing what, even on his case, we say must be a power that had existed for 10 years previously to impose such a scheme insofar as it satisfied the limits of at least 384. On my case, it's removing a power to do it simply by reference to the trigger conditions as set out in the statute. But my learned friend's construction on any view in my submission involves 40F7 not just creating a power, but removing a power which had existed for 10 years, also in an entirely silent way. And I simply draw attention, my lords, my lady, to at page 196. My lords and my lady are familiar with section 415A of the Act, but I just draw attention to it. It was introduced, and you can see this in the various footnotes here and back on page 404F7, back on page 193, and the relevant footnote you'll see is over the page at footnote 1. But both of these came in under the Financial Services Act 2010. So in my learned friend's case, 404F7 is not just creating powers, it is removing powers at the same time as a provision is introduced which says any power which the FCA has under any provision of this Act is not limited in any way by any other power which it has under any other provision of this Act. And we say that would be an extraordinary way to construe the statute. My lord, may I say something briefly about the redundancy point and the two limbs of 404(7)? In respect of A, I have reminded myself overnight of what a deed poll is, and I accept, my lord, that you can have these unilateral documents executed. But in my respectful submission, a provision is not redundant in this sense if it allows you, or allows the person supposed to benefit from it, to do more easily, cheaply, efficiently, and or practically what you could do in any event, but it allows you to do it in that more felicitous way. And in our submission in relation to subsection M, and indeed the 4 subsections preceding it, this is provided for in that statute because you create the debt against all the world simply by this statutorily conferred power.
But how does that work? There's a difference between A and B. Under B, which is the FOS section 404B provision, what the FCA can do is to include a provision. And I quite understand how, contrary to Mr. Herberg's case, that involved imposing a requirement. You say that doesn't involve imposing a requirement, it involves imposing a provision, and that can be the same as saying the Ombudsman scheme shall be banned and shall deal with complaints in accordance with the scheme. But A doesn't use that wording. It uses the wording a provision imposing requirements on the person. So the power in A is limited to a power to impose requirements on the authorised person to do something or refrain from doing something.
Yes, my lord, no, I accept that.
And I don't, I'm afraid, understand how in the context, for example, of M, you say that adds anything. You've still got to find a requirement under this that requires the authorised person to do something.
My lord, yes. The submission is limited to the fact that by having this specific power to impose a requirement, it may, the court will consider that, be more felicitous, more practicable, more efficient than the FCA having to create its own form of legal documentation. And I appreciate that one could, because I've seen what the deed poll can do. But in my submission, it is perfectly feasible that the draftsman considered that this would recognise that by giving this statutory power and putting on the requirement, it creates effectively in one stroke, once that requirement is imposed.
I'm not sure I'm understanding. What are you positing is the requirement that would have that effect under 7A?
That the law shall now see the debts owed, the sums which would have to be specified, payments from you to ABCD to be made under this scheme as debts.
But that wouldn't be a provision imposing a requirement on the person, would it?
Well, in my submission, that's what M is. My lord, point being really that
Because A only allows you to include a provision imposing a requirement on BlueCrest in this case?
My lord, yes, no, I see, I can see that the, any practical advantages are limited in that sense. But B, the fourth provision in my respectful submission is clearly not redundant. And as I have said, it's not, in my submission, a question of us putting eggs in particular baskets. This, as a matter of practice, is how we have operated and principally operated 404 F7 in relation to the times that we have operated it. And may I just show you back in Authorities 2 at 2231.
Sorry, Authorities 2.
So this is tab 69, tab 69, 2231. It's the
Sorry, Authorities Volume 8, is that?
9.
9.
Authorities, I'm sorry, volume, tab 69.
Thank you.
So this is the Affinian notice that we looked at in our first, when I first addressed you, and I showed you paragraph 12.2, the requirements that certain complaints have to be dealt with by the Ombudsman, which is how we operate subsection B. That's on page 2231. But I didn't show, and I show now, it's 2278, Annex C, which sets out precisely how this requirement operates and what the Ombudsman is to do. And that is how this provision has been operated. It is not something that would work to bind the Ombudsman absent this power in 404 F7B, and we therefore submit that it is not in any way OTOs. But we do also question how far my learned friend's argument could get him. As far as I understand my learned friend's argument, it is that he accepts the intention of Parliament was that this provision should not be OTOs, but that due to a drafting error it doesn't work and therefore is OTOs or useless, if you see what I mean. He says it doesn't work. But in my submission that neither undermines my argument nor supports his as a matter of statutory construction. Two more discrete points on this, my lord. In BlueCrest Supplementary Authorities at tab 3, page 24, this is on the admissibility of FCA guidance, and you are taken to Chief Constable of Cumbria and Wright at page 24. And the sidelined passage is paragraph 17. And this, I'm happy to say, is a submission that narrows the gap between the parties. If one looks just at the sideline passage 5 lined up to the end, there's sentences that begin, it may be of some persuasive authority. However, to my mind, that is the limit of its influence. It does not differ in that regard from a statement by an academic author in a textbook or an article. It does not enjoy any particular legal status. There's no satisfactory basis for the submission. It gives rise to a presumption. And on that basis, we can see that the FCA guidance, like any other document setting out an argument, is admissible in that sense. The point of something in an academic textbook or article is that it persuades you because it sets out a reasoned explanation for the particular point being made. It's no different to a submission that finds favour with the court. It is persuasive not because of who said it, but because of the logic with which it is said. But there is nothing in the FCA guidance on which my learned friend relies which has that quality of an argument or a reasoned analysis. He is literally saying, look what the FCA says and presume it to be true. And his own authority says that he can't do that. I turned then, my lord, to my learned friend's 4 conditions. And I just want to look if I may, at the question of loss in the context of a full multi-firm 404 scheme, because my learned friend's first contention is that loss is required, but at times that seems to have been moving or morphing into a submission that it has to be loss calculated in a way a court or tribunal would calculate it, and that is very much not the case. So if I may invite you back to 404 itself, which is at page 173 of the bundles. We can see, and I accept, that threshold condition at 1B, consumers have suffered loss or damage, and if you're reading that across, you may have a threshold condition of loss. But it's important to then look at what the rules say about that in 404A at page 176. So in relation to loss, subsection D, you may make rules as to the kinds of redress that are or are not to be made to consumers in specified descriptions of case, and the way in which redress is to be determined in specified descriptions of case. And then, my lord, there is a provision relating to 1D, subsection 4, over the page at 177. The FCA must exercise the power conferred as a result of subsection 1D so as to secure that in relation to any description of case, the only kinds of redress to be made are those which it considers to be just in relation to that description of case. And the point is then further emphasised by going over the page to 192. And this is 404, I apologise, page 192 of the authorities bundle, my lord, at section
Section.
404F. I'm so sorry, my lord, I should
Thank you.
on the afternoon of day 3, I should not be making that error. 404F subsection 1, redress includes interest and a remedy or relief which could not be awarded in legal proceedings. So when it comes to loss, even if my learned friend persuades you to read across from 404 the threshold requirement of some loss or damage, it's quite clear from the rules on which he relies that is not loss or damage limited to the way it might be calculated or quantified by a court.
Well, I wonder about that. This definition is not what redress always means, it's what it includes. And redress is used at various stages. And amongst other things, at 404(1), C, it says it considers as a threshold condition for a market-wide scheme, considers it's desirable to make rules for the purposes of securing that redress is made to the consumers in respect of the failure, having regard to other ways in which consumers may obtain redress.
Yeah.
Now, it would be very odd if redress, when it's first used there, meant something other than what the court could order, because it comes just after B. But one can see that when it's used in the second sense there, that you have to consider what the alternative forms of redress are, that it is very much intended to cover forms of redress that are not limited to actionable loss. And so it may be, that actually that definition, which is just an inclusive definition, says that sometimes, not always, redress may mean more than loss which the court could order, and this is a good example of it at the end of 401C. Is that a tenable interpretation?
I understand, my lord. May I press this point a little further by reference just to the structure at 177 of 404A and the rules to see whether I am right that redress for these purposes does include loss calculated in a different way to the way the court might do.
You might want to look at 404 sub 7 as well, which states the obvious, but it empowers the authority to determine the redress.
Yes, I'm very grateful, my lady. And the only other point, and then I will move on, was simply subsection 2 of 404A clearly restricts the matters dealt with in subsection 1B, which is what is a breach, to that which the way in which it would be held by a court or a tribunal to constitute a breach. My lord may recall having asked the question and been directed to 404A2 at an earlier stage.
But 404A are all rules which you can only impose if, in the opinion of the FCA, consumers have suffered or may in the future suffer actionable loss.
Yes, that's
So
the threshold condition.
That's the threshold condition.
Precisely. But when
But
it
you
comes,
say, if you, it's your case that as long as you've found somebody
Yeah.
who has suffered actionable loss, you can then impose rules that don't involve loss in the legal sense.
no, my lord, the person's needs to, for the threshold condition, yes, you need to suffer loss, exactly.
Yes,
But when you come to making the rules of the scheme
yes.
as to how much redress should be paid or how you quantify it, you are not required to make those rules mirror those that a court would take account of in the common law. And the reason I make that submission is there is a clear distinction between 404A2 and 404A3, which in relation to what is a breach and causation do contain a limitation. It must be the same as a court or tribunal would impose. But when it comes to quantification of loss and an amount of redress in subsection 4, all that is required is that it be just. And it's that clear distinction the draftsman's drawing between the limitation in sub 2 and sub 3, which deal with breach and causation, and the limitation in sub 4. So that's my submission. My lord, I will save the best to last and ask Mr. Rattan to reply after I have gone through all of that which Mr. Herberg has said. So I will now turn, as it were, to loss and the 4 conditions. This is the question of whether there was loss, as my learned friend put it, narrowed down really to what I think he would accept can fairly be characterised as a pleading point based on paragraph 173 of my statement of case, which is at supplementary bundle 3, tab 17, page 603. And there has already been quite a lot of debate about this paragraph, so I just very briefly draw attention to these points. In reading out the paragraph, my learned friend simply read, failure to appropriately manage this conflict resulted in a substandard investment management service being provided to the external fund and its investors. I draw attention to the lines that follow, in that the service provided involved both the inadequate arrangements and the inadequate disclosure described above. So there is not just, although I say it would be sufficient, not just the plea of a substandard service, but the cross-reference to the particularisation, and you'll see in the section marked authorities case which is being cross-referred. And similarly, we don't just say it's a substandard service. In the last line of this paragraph, the level of service received by the investors was therefore below that which could reasonably be expected to be commensurate with the fees paid by those investors. So there is a clear plea, not just that it was substandard, but that economically affects the value of the service received. And in my submission, that is sufficient. May I respectfully endorse the point, and I don't need to take it up because my Lord Justice Nugee raised it, but the Air Force India passage on which my learned friend accepted, he now entirely relies for this submission, quite clearly puts the burden of proof on the defendant if they wish to prove to the court at trial that in fact the service was worth no less. But since it has been raised, may I just show the final sequence in these authorities, which we didn't quite have time to get to yesterday, which is at authorities bundle tab 53, page 1410. We looked yesterday at Air Force India and at Eternal Break. And so it's the sideline passage at 1410 is paragraph 80. So Lord Reed, for the avoidance of doubt, the award of damages for skimped performance based on the difference between the value of the goods or services contracted for and those actually provided is not excluded by the principle in Robinson and Harman, but as an example of its application, that was recognised in Attorney General and Blake, and obviously we've traced through that line of authorities, but that is the most recent Supreme Court endorsement of what one could call the Air Force India principle.
What's Robinson and Harman principle?
Sorry, I apologise. May I just, yeah, I mean, Mr. Rattan will address that when he replies. It's a principle that doesn't exclude the principle on which I rely.
Shameless, but very nicely done.
My lord, the one other point, and I only do this because my learned friend specifically said you'd have expected them to come back with in their rejoinder if they had anything useful to say. We say that's wrong. We've pleaded it sufficiently. It's for them to prove. But that was a surprising submission in circumstances where, and if I go to supplementary bundle, tab 16, page 576. Amongst, so this is from our draft rejoinder, that I simply note at paragraph 18.2, we did specifically plead, in the light of that challenge, the very discrepant performance. You'll see 2011, the external fund, only half that of the internal fund, but there we are. But then as we go through the relevant period, you can see 5.82% versus 1112.13%, minus 15.57% versus 26.6.1 versus 26.37, and minus 0.62 versus 42.99. Now, of course, we accept, and that's why we're doing it this way, that we can't possibly, well, maybe we could possibly say, but we're not saying it, that very large discrepancy in performance results entirely from the Principle 8 breach. That would be a ridiculous way of asserting it, and we positively make the case we can't hypothesize the case in that way by sort of attributing it. But it's not the case that we sort of ignore financial performance, and we have certainly it's certainly not a case that my learned friend can say, well, maybe the external fund did much better than the internal fund, then what will your case be? So we have, in the rejoinder, responded to the general idea that we need to show some sort of discrepancy in performance. My lord, subject to anything my lord has to say, and Mr. Rattan will say in reply, those are some of my submissions on my part of the redress part of this appeal, and I will then turn to the amendment issues.
Just in relation to consumer, the consumer objective, which you took us to the definition of consumer, do you accept that when you're imposing a condition as a permission, sorry, a requirement as a condition of permission under 55L, that you are essentially doing something by reference to a fit and proper person, and that the consumer protection objective is the protection of consumers in the future, not protection of those consumers in respect of whom redress is being ordered?
May I make two submissions in relation to that? Because firstly, as we can see from the definition of consumers, it includes both. And certainly, in that situation, with fitness and propriety, then the consumer protection objective is obviously looking to future consumers. I mean, in any situation in which something bad is happening, unless you stop it happening, then future consumers are going to be affected. I suppose I wouldn't necessarily go so far as to say that excludes both limbs being potentially in play. One could, I can see, in ordering redress, be protecting consumers. I'm not sure I can take that further, as it were, but as a matter of logic, I could see the argument in that way.
But sorry, I just want to be clear. Is it Mr. Herberg's submission that you could justify imposing a requirement under 55L by reference to the consumer objective solely by reference to the consumers to whom redress was to be given, without having to have any element which justified it by reference to fitness in relation to protecting consumers in the future? Do you agree with that or not?
My lord, it would be not the usual run of cases, but I am constrained, I think, to say that on the face of the statute, that must be possible, because let us take an example of a firm that had, this is a hypothetical, but had committed some wrong in one business line, but no longer ran that business line. I mean, yes, I can see you could say, but generally to be allowed to continue business, it would still have that in mind. But I can see circumstances where the future consumers may no longer be related with or without the redress scheme to the particular wrong for which redress had been given. For example, I mean, I suppose, as I say, switching a line of business might be one such example. If the firm no longer carried on business, I suppose, might be another example. If other reasons had happened why the wrong would not take place in the future.
That relates to that specific firm, but there are maybe wider market
Yes,
firms
yes,
that would relate to
Yes.
other firms doing that sort
indeed.
of
I mean,
business.
the consumer protection objective, exactly. I was thinking about the future customers of that firm. No, my lady is absolutely right. Whenever one imposes this for the consumer protection objective, it is not, and I'll take instructions, but it is not simply for Mr. Smith or Mrs. Jones or the particular consumers who might have suffered that particular loss. You are taking that action in the wider public interest because, you know, and there's a lot of FCA publication and guidance about this. It's called, whether they call it messaging or whether they call it, you know, signalling to the market. It's the way that you drive conduct up by acting in this way in the consumer protected objective, and that does, of course, protect the market in the future.
Well, I understand that, and I as my lady says, there are perhaps two categories of future consumers who may be protected if you impose this requirement. One are the consumers of this firm on the basis that if you've done this, then unless you put it right, we're not satisfied that your future customers are at risk.
Yeah.
And the second is the deterrent effect, if one might put it in that way, so that others know not to behave like this, and that then prevents those who might otherwise be harmed in the class of their customers.
Exactly.
I understand. There are those two possibilities, but what I'm not clear on, because I'm afraid it's not obvious to me that it's right, that if neither of those arise, you can justify imposing a requirement as a condition of permission if the only consumer detriment you're concerned with is detriment to the consumers who you're ordering redress to.
My Mr. Smith and Mrs. Jones.
Well, I think you're Mr. Smith and Mrs. Jones were future customers. These are, if not, I misunderstood.
Yes,
I misunderstood. Imagine this is Mr. James,
yes.
who is never going to be a customer again.
No, my lord, I understand the question. I can't immediately think of a circumstance which neither of those would emerge, but yes. No, I mean, I'll make the submission and the court will decide the right answer. I think from the authority's point of view, although nobody can envisage a situation in which neither of those would be true, and certainly the FCA, to the best of our knowledge, haven't sought to do it, on the face of the wording, we would not accept that was necessarily a limitation, because the trigger is the trigger, and that is the statutory word.
And it may make quite a difference when one comes to the facts and, for example, what is proportionate.
My lord,
because
yes.
they are different.
They are.
Different objectives.
No, my lord is right, and as I say, I cannot conceive, and nobody behind me can conceive of circumstances in which neither of your two future customer examples were in play at all. So in my submission, I mean, that clearly is the, I may be unnecessarily reserving a caveat for a circumstance that I cannot envisage occurring.
All right, thank you.
If I get further instructions, I will put it out. But at the moment, I cannot envisage, and we cannot envisage a circumstance in which that would be a tenable position, or indeed a realistic position. In relation to the amendment application, if I can just start with some of my learned friends' more general propositions. And there was rightly talk about the protection of the subject, and we understand, and we all understand the balancing act that is involved here. But we also do ask the court, as a matter of experience and practicality, to recognise that contested litigation, using it most widely, contested dispute resolution, is impossible without, to use the Hansard reference, some flexibility on the part of the authority to respond to contentious and factual allegations which are unrestricted on everyone's case, that are made against them for the first time in tribunal proceedings, in order to refine their case, to say, oh, well, you might be right about that fact, but that still means that you were breached X, Y, or Z. It is in the nature of contested proceedings, particularly as the disputes are refined and case managed, that those sort of amendments are necessary, and each of my lords and my lady will have experience of that in a vast amount of litigation. And the consequences of a regime where, to use my learned friend's phrase, the statement of case must track and can only ever track the decision notice, would, in my respectful submission, be entirely impracticable. It also makes a nonsense, if I could put it that way, of the statutory scheme. The way my learned friend puts it, when you receive a warning notice with an obligation to make reasons, you can make representations, and effectively the authority can take them into account in the RDC's decision-making process, put forward what it considers in any way appropriate beyond my primary case and the same part, different part limitation, and issue a new decision notice. But the position is completely other once you have a decision notice, even though it has similar reasons, and the decision notice is effectively set in stone, even though the tribunal is another place where there are contested representations, in fact evidence, pleadings and submissions. That is now set in stone jurisdictionally, and we invite the tribunal to consider why, given the similarities in wording between section 387 and section 388, there should be this divergence between the outcomes that we see in these from these same similar notices. And this is particularly because the question of what the matter is clearly comes into existence before a decision notice is issued. So the word matter is, yes, that which is referred to the tribunal, but it is also the matter to which the precursor warning notice also relates. So why in a warning notice stage is one allowed to have this free hand to change the case, as my learned friend concedes, but with a decision notice that is not the case.
But is there a reference to the matter?
Yes, well,
At any stage prior to at least one decision notice?
Yes, my lord. If one goes to its BlueCrest Supplementary Authorities bundle, tab 1, does my lord see section 394? So 394(1), if a regulator gives a notice to which this section applies, and a warning notice is one of those notices, it must allow him access to the material on which it relied in taking the decision which gave rise to the obligation to give the notice, allow him access to any secondary material which in the regulator's opinion might undermine that decision. What is secondary material? We go over the page to page 3. Secondary material means material other than material falling within paragraph A of subsection 1, which was considered by the regulator, you'll see A, it's B that matters, was obtained by the regulator giving the notice in connection with the matter to which that notice relates, but was not considered by it in reaching that decision. So whatever matter means, it is not the decision notice because that doesn't exist at this particular time. And as I say, my learned friend accepts that matter at the warning notice stage, you are allowed to really change anything in the decision notice apart from that which you are statutorily prohibited from doing, which is taking a decision under a different part. And a similar point arises in relation to what is the justification for saying that a statement of case has to track the decision notice. And this is the last thing I will hand up, but may I just draw a comparison between, if we go to Authorities 1, section 3881B, which is at tab 4,
So sorry, could you give me the reference again?
page 148, so it's section 388 if you have FSMA. My lord sees a decision notice must, and the only requirements are those set out in A to E, and B is give the reasons of the regulator giving the notice for the decision to take the action to which the notice relates. And I've already submitted that seems inapposite to incorporate an alternative case, as it were, but you give the reasons. That's what the decision notice requires. And if I can just give you the reference, it's clear from Wilford, tab 44 of the authorities bundles, paragraph 51 and paragraph 73, that reasons is a relatively low threshold, and the unanimous decision in Wilford was that the reasons were adequate. It was a majority on the alternative remedy point. One Lord Justice said, not so sure about that, but we all agree the reasons are adequate. So it's a relatively low threshold to give the reasons. That's all the statute required. Conversely, if we can just hand up the tribunal rules. When it comes to the statement of case, and I apologise, once again, we have a lot of upper tribunal rules in the bundle, but not this one. So this is what a statement of case requires. And it's subsection 4, sorry, rule 4, subsection 2. This is schedule 3 to the upper tribunal rules, procedure in financial services and wholesale energy cases. My lords, my ladies.
Where have we got the other upper tribunal rules? So I
They
can
are
put this
in
in the right
authorities
place.
bundle 1, I think it's tab 12. It would fit in helpfully there, my lord.
Thank you. All right, we'll find a spot for it. But
So we
thank
see
you.
at 4.2, the statement of case must identify the statutory provisions providing for the referred action, state the reasons for the referred action, and that mirrors the decision notice, and subsection 3, set out all the matters and facts upon which the respondent relies to support the referred action. So at the statement of case stage, yes, there is a requirement to set out all facts and matters. But that is nothing, has no analogy at all with what you are required to do at the decision notice stage, which is merely to give reasons. And given that distinction, it is in my respectful submission absurd for my learned friend to make the submission that effectively, jurisdictionally, they have to be identical. It would be a perfectly proper decision notice if it just gave the reasons in relatively short form without setting out any of the story or the facts of matters, as my learned friend has put it. My lord, may I now turn to look at the, just as a discrete point, at the case made against me in relation to the second contested amendment, that whatever the jurisdiction test, this falls out with it. So I'm going to not repeat submissions about who's right about jurisdiction. I'm just going to posit this question. Is there a case in the decision notice, and we're not looking at any of the amendments here, that one, the underlying investors were clients for the purposes of Principle 8, and two, breaches of Principle 8 were committed in respect of the obligations to them by means of the inadequate disclosure? Because you have my submission that all the second contested amendment does is explain why the investors were clients as a matter of statutory deeming. My learned friend says, no, it's a new case. So let's put the amendments to one side and just ask ourselves what's in that original decision notice, and that's Supplementary Bundle 2, tab 13, page 480. Sorry, I apologise. My learned friend did it by reference to the decision notice, and I will do the same. So that's tab 12. And if we just track it through, there's a summary section at section 2. So if one goes to 4.28, the last sentence of 2.11, BlueCrest failure appropriately to manage this conflict resulted in a substandard investment management service being provided to the external fund and its investors. 2.12, given their nature, BlueCrest disclosures to its investors regarding the existence of the internal fund and various other matters were entirely insufficient and at times misleading. This is the unamended case. Right back a decision notice case. External investors were not told various things. And then moreover, 2.13, BlueCrest did not give its customers adequate disclosure of the conflict of interest. So that's the summary of the case.
Investors in the external fund accordingly didn't have sufficient information, so the customers again there identified.
As investors in the external fund, I'm grateful, my lord. And then goes on to the facts and matters section. As I say, it is right it's become something of a convention to set the story out in decision notices, but that's not because the statute said you had to. It's the way the authority does it, doubtless for very good reasons. So 4.4, we plead that BlueCrest was authorised to carry on various regulated activities, including managing investments and making arrangements. Those are, as you know, the regulated activities we seek to put back in the right place, directly next to. That explains why the external investors are clients, but it's pleaded here in the decision notice as a fact. And then at 4.24, the underlying investors had professional client status. And even on the harshest jurisdictional test, it is not satisfactory, or cannot be the right answer, for my learned friend to simply say, oh, well, it's only mentioned once and in passing. That's not how pleadings work. You don't get bonus points for repeating the same thing many times, quite the reverse. I have pleaded that the external funds investors are clients, and I have pleaded that it's the clients of whom the Principle 8 duties were breached. And then as we go through the allegations, 4.61, this is page 444, pursuant to the master sales agreement, BlueCrest was appointed by the investment management to market and sell subscriptions for investment in the external fund. This included BlueCrest providing presentations and issuing marketing materials for prospective investors in the external fund. These responsibilities were primarily carried out by BlueCrest sales and marketing team. So specific allegations here relating to the MSA itself, to the communications to prospective investors, And in the time available, I'm not going to sort of read it out, but I invite the court's attention to what follows in 4.62 to 4.67, which particularises the activities under the MSA carried out in respect of external the investors in the external fund, which we rely on for our allegation of breach of Principle 8. And then when it gets to 5.2, so this is then the summary of the case at 460. 5.2, based on the facts and matters set out above, the authority considers that BlueCrest breached Principle 8 in that it failed to manage conflicts of interest fairly between the investors and the external and internal fund, the investors. 5.6, over the relevant period, BlueCrest also failed to provide sufficient disclosure to investors in the external fund regarding, and then various matters.
Sorry, 5.6.
6. And then 5.8, accordingly, BlueCrest's arrangement for managing the conflict were not sufficient to ensure with reasonable confidence that the interests of its clients would not be damaged. BlueCrest's failure appropriately to manage this conflict resulted in a substandard investment management service being provided to the external fund and its investors. So even if I hadn't put forward the amendments in my submission, I would be perfectly entitled to say I have a properly pleaded case that the investors, the underlying investors, were clients, and Principle 8 was breached in relation to them by this very activity under the MSA of the disclosure you gave to them. It's all there in the unamended case. And it would be, in my submission, extraordinary in any jurisdiction to say that you cannot make the amendments I wish to make, which effectively puts that back in the right place. And you can test my learned friend's submission that it's a new case by simply looking at what is in red in the amendment and asking, well, what is new substantively? And obviously on the third and fourth contested amendments, there's the rule change. I understand that's a separate point. But other than that, this is exactly the same case. It is totally relabeling. And that is why in my submission, there is no credible argument that the third condition, the so-called duty condition, is not satisfied on the unamended pleading. The redress is to be paid to the investors, but it is they who are alleged to have been the target of the breach, being clients for the purposes of the breach, suffered loss. It all corresponds, and always did. We have another case, I accept that, in relation to the fund itself, but it has always been there. My Lord, let me, if I may, just briefly see if there's anything else I need to address you on. I've already made the submission that equally on any view, this second contested amendment was in play in relation to the matters debated between the parties before the notices were issued. 3 final points from me. On the Barras principle, I won't turn it up, but you will look at the Centrica case my learned friend relies on at tab 7, page 193, and you will notice there is a century of authorities, including many and the House of Lords Supreme Court stage, which are said to constitute that authoritative and settled practice. Here we have a number of decisions which are in no way consistent with each other, as has been seen by both sides' submissions, and now inviting the court to consider them. And in my submission, it is unreal. Barras principle is in any event, see paragraph 35 of Centrica, a presumption. It is unrealistic to consider, certainly after 2012, which was a more substantive amendment, that at any other time Parliament would have considered the handful of tribunal cases which touched upon this issue. So we say we are a long way from the Barras principle. We also note, my Lord, that the Jarbray case, which my learned friend alternately says is right or is wrong, depending on which submission he is making, is itself, as my learned friend pointed out, and he's right analytically, it was a backward-looking only case at the time it came to the tribunal. And I see what he says. He says it's only forward-looking because that's what you're trying to get in. But on his unamended state, it was a backward-looking case. And yet in that backward-looking case, the amendment was allowed. And in a sense, that supports, in my respectful submission, my proposition that this distinction isn't real for purposes of statutory construction. But certainly Chambre allowed an amendment in what was absent the amendment, clearly only a backward-looking case. And finally, my lords and my lady, just on discretion, and we are both agreed, subject to this court, which may not want to, but we invite the court to exercise its discretion if it gets to that stage. I simply, on the Burdett and Goodchild case, which you've looked at, Authorities, tab 3, page 96, 2593, paragraphs 84 to 88, you'll recall in Burdett and Goodchild, that's the most recent case where they did not allow a change from Principle 1 to Principle 2, but they also reached the conclusion, if it hadn't been for that jurisdictional conclusion, which they reached in the light of BlueCrest, and you've seen that, they would have exercised their discretion to allow the amendments. And you've already seen this tribunal, where it was satisfied it had jurisdiction on the second contested amendment, also exercised its discretion to permit the amendments. And that type of reasoning is likely to be of assistance to this court because it illustrates the type of factors the court would take into account. So, my lord, may I invite Mr. Ratton to play us out, as it were?
Yes, Mr. Ratton, we've been promised cake and ice cream for afters.
My lord, you've also been promised that the best has been saved until last, which I also may not strictly be able to honour. So, my lord, just to knock us on the head, Robinson and Harman, you can see the principle summarised in paragraph 515 of Guido van der Gaard for your note. That's Authorities, volume 4, tab 37, page 907. It's just one of the 19th century cases stating the basic measure of contract damages, namely that you should be put back insofar as money can do it in the same place you would have been if the contract had been performed. So it's just that principle. For my part, I'm going to focus symmetrically on the points that Mr. Burgess has addressed and very tightly on the new matters that he raised beyond their skeleton, so I won't repeat the points I've already made. There's one point I need to make about A1P1, one about doubtful penalisation, and one about what I described on day one as my sense check by reference to the FOS. As to A1P1, the new point that Mr. Burgess made was in the context of what specifically it's being contended should be read into section 55L by operation of the interpretive obligation in section 3 of the Human Rights Act. It had previously been suggested that it would be 3 perhaps of the 4 conditions as defined in that skeleton. I detected that by reference to the Crown and Weir, it was being suggested by Mr. Burgess there'd be an alternative implied term effectively, namely that the FCA must exercise its power proportionately in accordance with A1P1. And our short answer to that is that's just misconceived and unnecessary because the FCA is already a public authority which is under a duty to act compatibly with convention rights under section 6 of the Human Rights Act. And that includes acting compatibly with A1P1. And perhaps I might just read out the references to this rather than going to the case, given the time. But it's important to appreciate what was going on in Weir was that you were concerned with a confiscation order regime under the Proceeds of Crime Act, which didn't confer a significant measure of discretion on the person who had to make the confiscation order. And that's recorded in paragraph 4 of the Weir judgment, which is BlueCrest Supplemental Authorities tab 5. And it's precisely because of that lack of discretion that the issue arose in the case and they had to start considering, well, can we imply some language to the effect you don't have to make a confiscation order if it's disproportionate? But there's simply no reason to go down that line in circumstances where what we here do have is a discretionary power which has to be exercised in accordance with the Section 6 Human Rights Act duty. And insofar as it's suggested by Mr. Burgess that the Upper Tribunal on a non-disciplinary reference would be incapable of making the necessary findings as to proportionality, we don't agree that that's the case. Section 133(6)(a) sub A allows the Upper Tribunal, including on a non-disciplinary reference, to make findings as to fact and law, which could include a finding if the point is pleaded and is alleged by BlueCrest at the final hearing of the reference, that it's a disproportionate and therefore unlawful breach of A1P1. So it's not, the purpose of the arguments about construction we're making is not to try and foreclose that argument on BlueCrest's part. It's simply to note it has nothing to do with the proper interpretation of Section 55L or the Section 3 interpretive obligation under the Human Rights Act. It's a different kind of point, and it goes to the facts and to whether there's been a lawful exercise of the power in this case. So the second point, very briefly, on principle of doubtful penalisation. The way it was put in BlueCrest Skeleton argument is that the scope of that principle is that it applies to a penalty, brackets, including civil or regulatory penalties, which we wouldn't dissent from. That's paragraph 62 of their skirting. It was then suggested orally that it in fact applies to any civil liability. And the only authority cited for that was ESS and Sully, which is Authorities Volume 3, tab 34. Again, in the interest of time, I may just read out some references and the key points, and then they can be consulted from the transcript if it's considered helpful. Importantly, what that case involved was a civil liability linked to a crime. What it involved is sections 216 and 217 of the Insolvency Act 1986, which is to do with Phoenix companies, where you have a company that goes into liquidation, they start up a new company with a similar name, trying to exploit the goodwill of the old company, but not being burdened by any of its debts. And you can see that's set out in paragraph 3 of the judgment. And you can note in particular that section 216 is a criminal offence, and then section 217 says you as a director are liable for their debts if there's been a contravention of 216. So the personal liability is tied to the definition of the crime. And it's in that context that the court in that case read the two of them together coherently, see paragraph 61, and applied the principle of doubtful penalisation to both elements, 216 and 217, see paragraph 71. But that's a very specific context, i.e. a civil liability which is linked and is in adjacent subsections to a criminal provision. So we don't say that goes as far as to say you apply the principle whenever there's any civil liability. And finally, and very briefly, and conscious of the fact we've now reached the hard edge of 4:30, just in relation to what I described on day one as a sense check of the arguments both on human rights and doubtful penalisation, which is to ask, well, how would all of this apply to the FOS? Because it'd be quite startling if the consequence of BlueCrest's argument was that every monetary order that has been made by the FOS since the beginning of time has in fact been an unlawful violation of A1P1. And Mr. Burtis did venture an answer to that question, which is to say, well, the FOS has a cap on the compensation it can award. But that doesn't have any rational bearing on any of the points that BlueCrest are making. It has no bearing at all on whether it's in accordance with law or passes the test of legality. And even insofar as it's suggested it goes to proportionality, in fact, I mean, we should just clarify that that's not that cap on compensation by the FOS is not something that is built into FSMA in the sense there's a prescribed cap in FSMA. The FCA simply has a power to impose a cap, and that's a power which is exercised in rules, in DISP. But it's difficult to see why the contingency of where that cap is set as it happens by the FCA and the exercise of its statutory power should really have any bearing on any of these arguments. So we do say the slightly alarming consequence of the submissions you've heard on A1P1 and doubtful penalisation is that in fact the FOS in every monetary award it's made has been unlawful under A1P1 and has lacked the requisite clear authority to surmount the principle against doubtful penalisation. And we say that's equally wrong there as is for section 55L for all of the reasons outlined in our skeleton and in my submissions on day one. And so comes to the fact I've trespassed probably by 1 or 2 minutes, subject to any questions. That's all I was proposing to say.
No, thank you very much. Well, you won't be surprised to hear we'll reserve our judgments. I'm afraid, given the time of year, we can't promise that they'll be with you imminently, but we'll do our best to get them to you as soon as we sensibly can. When we do, they'll be in the usual form. You know the drill, but I'll just remind you, administrative and typological and grammatical corrections, not an opportunity to re-argue the case when you get the draft, and you are aware, but it bears repeating, of the importance of the embargo and of possible contempt liabilities that it's not strictly observed. Just remains to thank you all very much. Probably that ought to be extended to those who aren't in court as well. Thank you.
All rise this evening.